Good afternoon, everybody. I'm Austin Mahler. This is part 2 of our 3-part series on privilege. I'm going to be talking about without prejudice privilege today. Last week, Luca Krishlanen discussed litigation privilege, and next week he'll be talking about legal advice privilege. You'll be able to find both of those videos after they've gone up onto YouTube, but if you want to sign up for next Thursday's seminar, please do go onto Two Temple Gardens website and you can sign up to find out more about that very interesting topic. But today we'll be talking about a topic that is very near and dear to a lot of our hearts as litigators, and that is without prejudice privilege. When can you keep from the court, or potentially from another party to litigation, documents that you've shared with another party to litigation, potentially in the course of negotiations or not? And that's going to be one of our big questions today. Before I begin, I'll just ask if everyone can turn off their microphones and their cameras, because today's session is going to be recorded. If you have any questions, please feel free to add them to the chat at the bottom of Zoom, and I'll do my best to answer them at the end of the session. So without further ado, I've got 4 goals that I'd like to address today. First is going to be, why do we even have without prejudice privilege? We benefit from it, but what's the point of it? 2 is going to be, what is without prejudice privilege? To what documents does it attach? To what documents doesn't it attach? 3, I'm going to talk about the contexts in which without prejudice privilege applies. If a document is privileged in one context, does it maintain that privilege in a different context? And finally, I'll be talking about the labels that get thrown around so willy-nilly very often of without prejudice and without prejudice safest to costs. And my big question here is going to be, do they really matter? Short answer, yes, but I'll discuss with you when. Now, before turning to why we have a without prejudice rule, it's important to bear in mind how the rule operates generally. It's quite distinct from litigation privilege and legal advice privilege, because those can be considered forms of privilege which are unilateral in nature. They relate to documents internal to a party, which the party can therefore withhold from both the court and from other parties. Without prejudice, on the other hand, attaches to documents which by their very nature have already passed between parties. Now, what is the point of having such a protection? Why are you entitled to withhold these documents from the court? Well, the rule operates through a combination of contract and public policy. Neither one provides the whole answer, and so a fusion of the two is probably the best way to look at it. The public policy aspects were best summarized by Lord Justice Oliver in the 1984 case of Cuts in a Head, where he effectively said, there's a public policy in favor of encouraging the parties to approach settlement. And in particular, there's a public policy to encourage the parties to approach settlement with cards on the table and open, honest approaches, not to hold back in settlement negotiations. And so the without prejudice rule functions exactly as the name intends, to make sure that if you say something in the course of negotiation which might prejudice you were it to come out in trial, you need not fear that that will be the case. In other words, you can comfortably and safely share admissions or make concessions in negotiation without fear of them coming back to bite you, without fear that in trial you will be prejudiced by the positions you've taken in negotiation. And if the parties have that comfort, so goes the theory, they will approach negotiation in a more open-minded and cards-on-the-table manner, which will encourage the parties to reach settlement. Now that gets us only so far, because there are limitations to the without prejudice rule. For example, where a document is marked without prejudice, subject safest to costs. And we'll discuss in a few moments why or in what way that is different. But why is it different? Public policy doesn't provide an out here. And in this side, it's best to consider the without prejudice rule to have some grounding in contract. And that is that there's an implied or express agreement between the parties that matters relating to costs can be explored, and without prejudice communications can be shared as they relate to costs. So if we bear in mind the purpose of the without prejudice rule, which is ultimately encouraging settlement, That helps us with the next step. What are the documents to which the without prejudice rule attaches? Now, if there is a single phrase that you take away from this entire webinar, it is this: a genuine attempt to compromise a dispute between the parties. And if I could take it one step further, if there's a single slide that you're going to take away from this entire webinar, it's going to be this one, because I want to break down each of these 4 parts to the phrase. Because if you can remember these 4 parts, that is the key to understanding what document attracts the privilege and what does not. Now, the way these 4 questions are answered is a feature of the fact that this is a bilateral form of privilege. It is a document passing between the parties. In a unilateral case, the question usually before the court is what the subjective intention of the party creating the document was. It's different in the case of a bilateral privilege, because in that case, in our case, the recipient of the document needs to be in a position to determine if they can rely on that document in court or not. Now, this very question was considered by Crane J and Pearson Education Limited and Prentice Hall India Private Limited. That was a 2005 case concerning royalties for books published in India. The claimant sent an open letter to the defendant. The claimant also followed it up with a letter marked without prejudice. The defendant responded only with a letter marked without prejudice and then sought to rely on all 3 documents in an application to set aside permission to serve out of the jurisdiction. Crane J considered the previous authorities of South Shropshire District Council in Amos, which was a 1986 Court of Appeal decision, and Sharing Corp and Cipla and Neolab Limited, which was a 2004 High Court decision. And Crane J came to the conclusion that in this bilateral privilege case, the only significant factor was the objective intention of the parties, and he rejected the commentary dicta by Parker L.J. in South Shropshire, which suggested that evidence of the subjective intentions of the parties would be admissible. Looking at the first issue of a genuine attempt, there has to be both a genuine issue and a genuine attempt to resolve it. The genuine issue point has a bit of a wrinkle in it because of a 1954 Court of Appeal decision by Lord Denning in Rabin and Mendoza, where 2 parties agreed to consult a surveyor on a without prejudice basis before they actually had a difference between them. And in Rabin and Mendoza, Lord Denning allowed that surveyor's report to be protected by the without prejudice privilege. That case is only really justifiable on a contractual basis because there is no public policy basis to justify imposing the privilege in a case where there's no genuine dispute. And shortly we'll be contrasting this case with Stack's claimants in Nova Scotia, which shows us that in a 3-party case, in a multi-party case where only 2 parties who don't have a genuine dispute agree to discuss things on a without prejudice basis, their discussions will not be protected by the privilege. So the more common case for genuine attempts to come up, and I say more common, really this is itself quite a rare case, is a case of unambiguous impropriety. Now, unambiguous impropriety is a term coined by Lord Justice Hoffman, as he then was, in Forster and Friedland. It goes together with blackmail and perjury. And in a sense, the without prejudice rule does not protect communications, which are really just a cloak for an attempt at perjury or blackmail, or, as Lord Justice Hoffman then said, unambiguous impropriety. By way of example, I was involved in a case a little over a year ago for a freezing injunction. We represented applicants who had paid about £500,000 in advance rent. The rental contract fell through, and they sought recovery of their money. In an email back, headed without prejudice, the people who were holding the money said that they were slowly fritting it away, and if we agreed to accept a significantly smaller sum in full and final settlement, they would put their solicitors in funds. But if we did not, they would continue spending the money, and there probably wouldn't be any for us. Now, we went and sought a freezing injunction. And when we sought the freezing injunction, the judge was satisfied that this was a case of unambiguous impropriety, we were therefore entitled to rely upon that email as evidence in favor of obtaining a freezing injunction, because in effect, the other side had been using the without prejudice label to attempt to force our hand and to force us to accept a lesser settlement for fear that they would basically abscond with all of the money to which we were rightly entitled. The unambiguous impropriety exception is quite a narrow exception and should only be applied when there's really a clear case that there's been an abuse of privilege, as in a case like ours, where we were really being blackmailed. Other than those type of cases, it's a very rare situation that you'll actually come across a case of unambiguous impropriety where the privilege is not disapplied for some other reason as well. The next issue is the requirement that the communication must be to compromise a dispute. And this is the point on which the parties are most likely to fall down. This is the one that comes up as an issue most often and has the most scope for argument one way and the other as well. One of the leading cases on this is Bradford and Bingley and Rashid, which was a judgment of the House of Lords in 2006. In that case, the claimant claimed mortgage arrears from the defendant. The defendant responded with a letter saying he would offer £500 in full and final settlement of the outstanding sum. When it came to trial, and the claimant sought the full outstanding sum, the defendant defended only on the basis of limitation. The claimant argued that by sending that letter, sending that offer for £500, the defendant had admitted and affirmed the debt, and therefore limitation didn't apply. The defendant argued that that offer of £500 was privileged and could not be relied upon by the claimant. The House of Lords unanimously disagreed with the defendant. However, they came to that conclusion by a number of different paths. Lord Brown, however, had the support of the majority when he said that the without prejudice rule has no application to apparently open communications designed only to discuss the repayment of an admitted liability, rather than to negotiate and compromise a disputed liability. Now, in the case of Bradford and Bingley, Mr. Rashid did not dispute the amount of the outstanding debt. He did not dispute the bank's entitlement to recover the full outstanding debt. Rather, he just offered a smaller amount in compromise. He was just seeking a concession. He was not seeking any form of compromise. Perhaps the outcome would have been different had there been a dispute as to how much the bank was owed, or had there been a dispute as to the bank's entitlement to the mortgage arrears. But because there was none, his offer was not an offer to compromise, and therefore the without prejudice rule did not apply. A similar judgment was reached by Mr. Justice Coulson in the 2010 case of Shepherd Construction and Berners. Ultimately, what the court is looking at when determining whether or not this is an offer to compromise is there actually a dispute? Does this communication or this line of communication actually attempt to narrow the issues between the parties? Or is it really just discussing something that's not actually in dispute? I want to focus for a moment on that idea of a line of communications, because the without prejudice privilege doesn't just attach to a single document that contains an offer. It attaches to the entire course of communications in a negotiation or towards a negotiation, whether it results in settlement or it does not. Now, this raises issues both for documents internal to negotiations and for the first document in a negotiation. Looking at the internal documents first, it might be that a particular document exchanged in the course of a negotiation doesn't actually move things forward. It might not contain an offer, but it might contain some admissions that one party wishes to rely upon. And so what the court will look at is, was this document in the course of communications that satisfied this test? Was the course of communications one which was aimed at compromise? And if it was, then that internal document, internal to those communications, will be privileged and will not be usable in court. An issue arises with the first document in negotiations as well, and this is the opening shot issue. The problem is this: the first shot, the opening piece of communication, can't be said to be in the course of a communication to compromise if there is no response. Likewise, you also can't say that it has the contractual underpinning of the without prejudice rule, because the other side can't be deemed to have accepted an agreement to discuss matters without prejudice. And so there's only the public policy protection. And there's a quite useful judgment by Lord Justice Lloyd in Standard and Yentminster Homes, which was an unreported case from 1991, in which he said that the opening shot of negotiations may well be the subject of privilege where, for example, a person puts forward a claim and in the same breath offers to take something less in settlement. Where the opening shot is an assertion of a person's claim and nothing more than that, then prima facie, it is not protected. It's therefore especially important, if one is making the opening shot in negotiations, to ensure that it is crystal clear that their intention is to put forward an offer and not simply to state their position. That is one of the instances where the without prejudice label can assist us. So from a practical perspective, when you find yourself wanting to rely on a document, whether it's an opening shot or otherwise, ask yourself, is this document an attempt to compromise something that's an issue, or is it not? Going back to my freezing injunction example, when the people who were holding my client's money said that they were going to continue fritting it away unless we accepted the offer, they didn't dispute that we were entitled to the entire sum. They didn't challenge quantum, and they didn't challenge liability. We also argued to the judge in our freezing injunction that therefore their offer was not actually an attempt to compromise anything, and therefore it was not protected by the without prejudice privilege, even leaving aside the issue of unambiguous impropriety. And the judge accepted that as well. Our third element is a dispute. There must be a dispute between the parties, and this is, you'll be glad to hear, much simpler than the previous two. It does not require ongoing litigation, but it does require a triable issue. It requires there to be a dispute between the parties which is capable of resolution by the court if they aren't able to reach agreement. There are a number of Court of Appeal authorities on this. Sue and Mace in 2016 is one of them. Framlington Group and AXA Framlington Group is another Court of Appeal authority. And finally, Best Buy Co. and Worldwide Sales Corp. España. All three of these cases considered what exactly the nature of the dispute is, how far advanced it must be. To summarize, the Court of Appeal in Sue and Mace agreed with ODJ's judgment in BE and DE that there needs to be a reasonably coet and definable issue or a series of issues between the parties, not just a number of reciprocal differences or grievances. In Best Buy, the Court of Appeal concluded that for a document to be treated as benefiting from the without prejudice privilege, the issues between the parties have to be sufficiently advanced such that objectively they might consider that they have reached the point where the without prejudice zone would be appropriate. Obviously, in that case, we're talking about significantly pre-litigation. And finally, in Framlington, which is probably a simpler name to remember than Framlington Group Limited and AXA Framlington Group Limited, the Court of Appeal concluded that the parties don't have to have actually contemplated litigation, but they have to have got to the point where they might reasonably have contemplated that litigation would follow if they don't reach an agreement. If those elements are satisfied, there is a dispute and the document is capable of attracting the privilege. Obviously, if litigation is already ongoing, and if there's a real triable issue, then there will be no question here. The fourth and final element is that there has to be a dispute between the parties, and that is between the parties to the communication. Now that might seem like an obvious one, but there's actually a wrinkle that we really have to watch out for here. In the 2007 case of Stax claimants in Nova Scotia Bank, Warren J. had to consider a case where solicitors for the claimants had a chat with solicitors for the Part 20 defendants. Now, there was no issue between the claimants and the Part 20 defendants. They had no direct dispute between them. Their chat was supposedly on a without prejudice basis. And the question Warren J. had to consider is, was that a privileged conversation? Could that be protected from the defendants who were not party from the chat? He concluded that it was not protected and it was admissible evidence because there wasn't a dispute between the parties to the communication. Now, this is distinct from the case where there is in fact a dispute between the parties to the communication, and in Stacks, had there been a dispute between the claimants and the Part 20 defendants, and had the without prejudice chat been aimed at a genuine attempt to compromise that dispute, then the privilege would have attached and those documents would not have been disclosable. And that makes sense if we remember the public policy reasons for this privilege, because after all, if two of many parties to litigation are able to negotiate with their cards on the table without fear that what they say or what they disclose might eventually be disclosed to another party to the litigation, that they're more likely to reach settlement. And that is what the court is trying to encourage. And that is ultimately what the House of Lords said in 1989 in Rush and Tompkinson's and Greater London Council, where they decided that the without prejudice communications would be privileged both in this litigation and between these parties, and also in any related litigation, or even in any subsequent litigation connected with the same subject matter. This is a rather broad application of the rule, but one which supports the ultimate public policy of ensuring the parties feel comfortable negotiating in good faith and with their cards on the table. And it's important to bear in mind that the rule applies also to litigation between related parties, not only the parties to the communication. A problem arises, however, where you have separate litigation with the same parties that doesn't actually touch on any of the same issues. That's not covered by Lord Griffith's judgment in Rush and Tompkinson's, so it's currently unclear how the privilege would apply in that case. At the moment, it's best to err on the side of caution and not try to rely on such documentation in related litigation, but it's very much a watch this space type of situation. If you ask me my view, it would undermine the public policy if the court allowed documents to be relied on in a later case, which were not admissible in the first case, unless they fell into one of the contexts where the without prejudice rule does not apply to them, or where the privilege is set aside. So now that we've concluded the four elements of what constitutes a without prejudice document, namely a genuine attempt to compromise a dispute between the parties, it's time we move to our third topic. That is, in what context does the without prejudice privilege apply? In other words, what circumstances make an otherwise privileged document admissible? Fortunately, this is one of the fields in which the Court of Appeal has given us a very helpful judgment containing all of the primary principles in one place. And that's the 2001 case of Unilever and Procter & Gamble. Now, this is probably a good time, considering the number of cases I've thrown at you, to mention that all of the cases and all of the slides that I've presented are going to be available and will be circulated after the webinar. Turning then to the Unilever case. The Court of Appeal set out effectively 8 exceptions to the rule. But really what these are circumstances where a document which is privileged in one context is not in another. So you see all 8 on the screen here. I'll just go down the list. Establishing if there was an agreement. A communication, a negotiating document, which is privileged in determining a question of liability, will be admissible if an agreement is supposedly reached, to determine if it has in fact been reached, if, for example, that document contains an offer. Likewise, setting aside an agreement for misrepresentation, fraud, or undue influence. And this makes a lot of sense, because the parties aren't able to police enforcement of an agreement if they can't rely on these sorts of documents on the pre-agreement negotiations in order to ensure that the agreement is being complied with. Likewise, issue estoppel, if there's been a statement which was detrimentally relied upon. That's a little bit of a different case, but doesn't have to do specifically with the admissions contained in a without prejudice piece of correspondence, rather the nature of the statements made and how that impacted on the recipient. Again, a case that doesn't quite have to do with admissions themselves is explaining a delay or other procedural behavior. Normally here, it will be enough, and when it is enough, it is all that is admissible, to simply say that there were without prejudice negotiations without detailing their content. However, it will occasionally be necessary when explaining a delay or failure to take a procedural step to actually admit the entirety of the without prejudice communications, and they will be admissible in this context. Again, not as evidence of the information contained with them, not as evidence of the admission. The next example is where the privilege is asserted as a cloak for unambiguous impropriety, blackmail, or perjury, and that's a topic we've discussed already. Matrimonial cases, they have a different privilege rule. Next is a case where public policy does not arise, and I'll come back to that in a moment. And finally, there are costs proceedings where the without prejudice saves to costs term is used. I want to pick up on those last two cases, where the public policy doesn't apply and the costs case. Looking at the public policy, there was another Court of Appeal decision by then Lord Justice Hoffman called Muller and Lindsley and Mortimer. Now, in this case, the claimant settled a claim against a third party that was in mitigation of their losses. They then brought proceedings against their solicitors in negligence for the difference in their losses. A question came up whether the negotiations with the original third party were disclosable in this later litigation. Lord Justice Hoffman concluded that the purpose of the without prejudice privilege is to protect admissions, to ensure that a party feels comfortable making admissions in negotiations. And therefore, the reason that these documents were sought in the later proceedings were not relating to admissions that were made in the first instance, but rather because the solicitors wanted to show that the claimants had not properly mitigated their loss. And in order to do so, they needed to look at the manner in which negotiations had been conducted. Since these documents were sought as evidence of the manner in which negotiations were conducted, and not as evidence of the admissions contained within them, Lord Justice Hoffman concluded that the public policy did not extend to prevent disclosure of these documents, and they were admissible. Turning then to the case of costs, this takes us to the contractual basis for the without prejudice rule. Because if we recall, there is no public policy reason why the court should not see a document in the context of liability, but should see a document in the context of costs. The limitation, therefore, is one that comes from contract, where the parties agree that their correspondence will be on a without prejudice save as to costs basis. It will then be admissible on the question of costs. And this is quite important because it means that where a document is simply marked without prejudice and is sufficient to satisfy the requirements of the without prejudice privilege, it will not be admissible on the question of costs unless there is a clear objective intention that the parties agreed that it would be. Contract doesn't get us the whole way because it doesn't explain why a document will be admissible on the question of costs if it is marked without prejudice, save as to costs, but it hasn't actually elicited a response agreeing to negotiate on that basis. However, in cut, Lord Justice Oliver said that the public policy allows the parties to modify the restriction in this way and to potentially unilaterally modify the restriction so that documents can be relied on for the purposes of costs, so long as the document on its face contains that modification. One more recent addition to the list of exceptions came out in the 2010 Supreme Court case of Ocean Bulk Shipping and Trading and TMT Asia. In that case, the Supreme Court concluded that another situation where otherwise inadmissible privileged documents will be admissible is when those without prejudice communications are needed to establish the factual matrix of a contract that was concluded at the end of them. And while we're looking at situations where a contract was concluded at the end of the negotiations, it's useful to turn to the 2019 High Court case of BGC Brokers and Tradition. Now, most of the cases we've been addressing so far are situations where the privilege attaches to documents that arose in the course of negotiations which did not ultimately lead to settlement. In BGC Brokers, a settlement agreement was reached. The claimants, BGC, had settled with Mr. Cudahy, who had been one of a number of defendants, and they settled after having a without prejudice interview. Notes from that interview were attached to the settlement agreement, which included a clause warranting that his representations in that interview had been accurate. The settlement agreement and the interview notes were disclosed to Tradition, another one of the defendants. However, the interview notes were redacted. Tradition applied to have those interview notes admitted unredacted. Master Davison considered the case before him, and he came to the conclusion that even though the interview would have been privileged as a negotiating tool, as part of the settlement agreement, it was not a privileged communication. He bore in mind that it was common ground between the parties that the settlement agreement itself is not a privileged document. It's a contract like any other contract. Now, these interview notes would have been privileged if they were evidence simply of the negotiation, but they were also part of an express warranty, and therefore they were part of the admissible contract that was reached at the end of the negotiations, and they therefore lost the privilege by their inclusion as terms of the contract. And that takes us to our next and final topic, which is, what about the magic words? Does it matter if you say without prejudice save as to costs on the top of a letter? Can you ignore it when somebody else does? Well, we've already touched on without prejudice save as to costs. That does have significance because that creates an exception to the general rule of privilege and enables an otherwise privileged document to be admissible on the question of costs. But what about the words without prejudice themselves? Unlike the words save as to costs, the words without prejudice don't have any magic to them. In Bradford and Bingley and Rashid, Lord Mance said, neither a dispute nor a concession or offer to compromise can be conjured out of mere words. The words themselves don't render the communication without prejudice. They do, however, give evidence of the objective intention of the parties. And when the court considers the four aspects we looked at before, a genuine attempt to compromise a dispute between the parties, the court will look at the words without prejudice as strong evidence of how the parties intended a specific aspect of the communication to be treated. In Williams and Hull, Mr. Justice Arnold suggested that the words created a rebuttable presumption in favor of the privilege. That is perhaps the better and safer way of looking at those words. In the context of a genuine negotiation, if one encounters the words without prejudice, then those will usually be adequate to establish the objective intention to treat the documents as privileged. And that fits with the judgment of Mr. Justice Colson in Shepherd Construction and Berners, because what he was effectively saying there was, even though we've got these words without prejudice, there isn't a genuine negotiation, and the presumption can be displaced when what the parties are really just doing is discussing an agreed set of facts, or at the very least, a situation where liability and quantum are already agreed. So while the words without prejudice will be of assistance in resolving a doubt, for example, in the case of a first shot piece of correspondence, they're not going to be conclusive. And therefore, it's always important to apply that four-step analysis when you're trying to decide whether or not a document is something that you can rely on in trial for admissions contained within it. So just to recap the 4 topics we've covered today. Why does the without prejudice privilege exist? Well, it's a public policy that encourages settlement without the fear that admissions you make in the course of negotiations will come back to bite you. What attracts the without prejudice privilege? Any genuine attempt to compromise a dispute between the parties. And those are the magic words that I'd like you to take away from today's webinar. In what contexts do privileged documents that otherwise attract without prejudice privilege lose that privilege? Well, we have the 8 categories in Unilever and Procter & Gamble. We have the context of a settlement situation in ocean bulk shipping. And finally, we have the example in BGC and Tradition where the without prejudice negotiations became incorporated in the contract. Finally, what weight do we give labels of without prejudice or without prejudice save as to costs? In the case of save as to costs, those are significant words which carve out the right to rely for the purposes of costs. And in the absence of those words or words to that effect, without prejudice documentation cannot even be relied upon for the purpose of costs. As far as the weight to give the without prejudice label itself, that is evidence of the objective intention of the parties, and it's safest to treat it as a rebuttable presumption that the document is privileged. And you can rebut that presumption by showing that the document is not, in fact, a genuine attempt to compromise a dispute between the parties. Thank you so much for joining me today. It's been a privilege presenting this topic to you. I'm happy to answer any questions you may have over Zoom or over email. Thanks again. It looks like we've actually got one question already. I noticed in the blurb for this talk I mentioned I would be talking about mediation, and I haven't actually touched on that. And the question is there a specific without prejudice rule as it relates to mediation? This question came up in 2015 in the High Court case of Interactive Technology Corporation and Firster before Mrs. Justice Rose. She concluded that there isn't a specific mediation privilege, or there isn't a specific without prejudice rule for mediation. There might yet be one that arises in the future, and there might be a specific rule as relates to communications between a party and the mediator. But at least as regards communications between the parties, there isn't a specific rule. Rather, the general without prejudice rule applies. And relying on Unilever, the position is effectively the entire course of mediation is a discussion between the parties that, if it's conducted properly, should be aimed at negotiation and settlement. And so we don't carve up the minutes of a mediation to determine what's an admission and what is a potentially admissible document. Rather, the privilege is attracted by the entire course of the mediation, and the entirety of the mediation minutes will be privileged under the without prejudice rule, even if they contain statements, assertions, admissions, simple puffs. Of course, the normal exceptions will apply. Those are, as I said, the 8 exceptions we've touched on in Unilever, as well as ocean bulk shipping and BGC. Of course, it's a burden on the party alleging that a case is an exception to show that that exception applies. So in the absence of approved exception, the entire course of the mediation and the entirety of the minutes of a mediation will be protected by the without prejudice rule. We've got one other question, but I'm looking at the time. I realized we got a bit of a late start and have overrun as well. So what I'm going to ask is if anyone has any more questions, please drop them in an email to me. I do see at least one more question, which I will get back to by email. But apart from that, it just remains for me to say thank you once again. And please don't hesitate to get in touch with any questions you may have. Thanks again.